Between all of them, they have about 100 firearms. And the state says, you've already got your guns. You don't need a new one. And as a result, you are not suffering irreparable harms. This is utter arrogance for the state to be making a determination as to, number one, how many firearms you should have, and number two, the types of firearms that you should have. It is effectively the state saying, we simply know better than you do. Now, today we are going to be discussing an update to a California case called Boland V Banta. This is a challenge to California's roster of safe handguns. Now, while this is specific to California, this video is actually being done because the pleadings that the state attorney general has put forth in this case are extraordinarily instructive to how other states are going to be trying to argue that the Second Amendment simply does not apply to the rules and laws that they have established in their home states, restricting a person's ability to be able to exercise their Second Amendment rights. It sort of peels back the curtain, so to speak, and is showing the legal arguments that we're now going to start seeing cropping up in jurisdictions throughout the country. All right, so first of all, what is Boland V Banta? California has what's called a roster of handguns that are certified for sale by FFLs within the state of California. In order for a gun manufacturer to basically be allowed to sell a firearm in California through an FFL, the firearm has to be submitted to the California Department of Justice, where they'll undergo a drop test to ensure that the gun doesn't go off if the loaded gun is dropped. Then they're going to have to show that the firearm has a magazine disconnect, has a loaded chamber indicator, and has micro-stamping technology. Since micro-stamping technology does not really exist, the requirement that a firearm have micro-stamping technology went into effect in 2014. There have been no new firearms, with a couple of minor exceptions. There have been no new firearms added to the California roster of safe handguns since 2014, almost 10 years. Hey guys, this video is being sponsored by USCCA, and they're doing a giveaway right now. It's unbelievably cool, and you can find out all about it in the description below this video. It does end soon. I can tell you, or at least give you a hint as to what it is they're giving away. It can fit in your holster. Boland challenged this roster, claiming that it violated the constitutional test as established in New York State Rifle and Pistol Association v. Bruin. They also asked that a preliminary injunction be issued prohibiting the state from enforcing the roster until the case has been fully litigated. Judge Carmack, federal district court judge in California, agreed with the plaintiff's position and issued a restraining order, effectively, an injunction. He didn't enjoin the entire enforcement. He said that the drop test may actually be constitutional. Didn't say that it was, just said it may be. And as a result of that, he could not enjoin the enforcement of that aspect of the roster as the case makes its way through trial. He did, however, say that the magazine disconnect, the loaded chamber indicator, and the micro-stamping technology fell all outside the constitutional, purview of the Second Amendment, and as a result, he enjoined the enforcement of that. And we'll talk a little bit in a second about what is required for a statute to be enjoined from its enforcement. After he issued his injunction, the state of California appealed that injunction to the Ninth Circuit Court of Appeals. This is what is now about to be litigated. All right. So we should be actually getting a ruling by the end of August on this. Well, California has just issued their moving papers in this enjoinment argument. And like I said, it's absolutely fascinating to see the mindset of where the anti-gun lawyers are going with on this. To begin with, they correctly argue that in order for a plaintiff to claim that their Second Amendment rights have been violated, they need to actually show that the Second Amendment applies either to them or to the underlying conduct. This is correct. This is exactly what Justice Thomas said in the Bruin decision. Once they've overcome that hurdle, the burden then shifts to the state to show how the state's law is consistent with the nation's history, tradition of firearms regulations that existed at the time of the ratification in 1791. Well, we've always been very, very curious to see what the state's arguments were going to be as it related to that, because, you know, at first blush, we can all look at the vast majority of the firearms regulations that exist out in the United States, and we can say these are absolutely inconsistent with the history of firearms regulations that existed in 1791. Now, to be very, very specific, Justice Thomas, in his opinion, did not say that the state needs to be able to show that there was an exact match of a law in 1791 to the law that's currently being litigated today. All right. He said that depending upon the situation, a, quote, more nuanced approach can be used, but they have to show that there is a direct analogy. The law that is being questioned today must have more similarities to a law that existed in 1791 than differences. Okay. All right. So the question, like I said, became how is the state going to do this? And what they seem to be doing is attacking the first part of this test. They seem to be looking at it and saying that the Second Amendment never applies. It's also interesting to see the level of arrogance that the state is articulating. I want to read a couple of direct quotes from their moving papers. Properly analyzed, however, the challenged public safety requirements are consistent with historical traditions of regulations aimed at reducing the harm of firearms when they do not operate as intending and tracing firearms used in crimes. Okay, this is just factually inaccurate, right? We never had any sort of a regulatory environment that existed in 1791 where the state had some level of crime-fighting methodology associated with individual firearms. So they literally are making this stuff up. At a very fundamental level, I would say they're trying to perpetrate a fraud on the court. That notwithstanding, another little tidbit, which I think is absolutely fantastic, on page 4 of their moving papers, training with firearms would lead to the absurd result that in future constitutional challenges, any proposed conduct touching on any type of firearms training would be presumptively protected by the plain text of the Second Amendment. Yeah, that's kind of the point. All right, that's exactly why Justice Thomas wrote it the way he did. Once the Second Amendment has been implicated, the case isn't over. It's just simply that the burden shifts now to the state to show how the regulation is consistent with the history of regulatory traditions. But to argue that the Second Amendment doesn't even apply, I think is just absolutely disingenuous. The other one that I love, again, on the bottom of page 4, but this approach would mean that any regulation having any effect on firearms possession or use could be presumptively protected by the Second Amendment's plain text. For example, under plaintiff's approach, generally applicable zoning laws Prohibiting retail sales in residential neighborhoods, including those of firearms, could meet the plain text inquiry and then be subject to historical scrutiny. So too, a standard tax that encumbered an individual's ability to purchase a handgun, or a law that required all retailers to retain records of commercial sales. Yeah, again, I'm just befuddled that the state is even making this argument. They're not saying that these laws would automatically be unconstitutional. It would just require that the state be able to show how it is consistent with our nation's history of firearms regulations that existed in 1791. They are appalled. They are infuriated that they would even have to go through that analysis. How dare the individual plaintiff require that the state justify itself? That is essentially the argument that they're making. Again, this is consistent with what could only basically be described as the arrogant mindset of the state demanding that they have the ability to infringe on law-abiding citizens' rights. Now, in another video earlier, we had talked about how they're also trying to attack the concept of the people, who the people actually are. We're not really discussing that in this particular video, but these are both now consistent arguments. So the state is saying Second Amendment doesn't apply because the plaintiff involved in this does not fall within the scope of the people. And now they're saying the Second Amendment doesn't apply basically because we just don't want it to apply. All right, it's unbelievably disingenuous. Now, I should mention, the state may not be throwing all of their arrows into the quiver on this one. This is simply a challenge to a ruling that a lower court judge issued on a preliminary injunction. It is not an attempt to overturn the full ruling on this case. And as a result of that, they may be kind of holding off a little bit. Appellate courts are very, very reluctant to insert themselves into a lower court's, process as it's developing an opinion. They typically will tell the state, no, we're going to uphold the injunction. We may disagree with the mindset of the judge, and when the judge ultimately makes their ruling, we're probably going to do our best to overturn it, but we don't want to get involved at this particular point. And I suspect that the state has already sort of accepted the fact that that's probably what's going to happen. Another aspect of this, which I kind of referenced a little bit at the beginning of the video, is whether or not the individuals applying for the injunction should have even received it to begin with. For an injunction to be issued, the lower court judge needs to find two specific things. Number one, they need to find that the plaintiffs are very likely to prevail on their argument. Okay, so they have to sort of do like a little mini analysis of what the ultimate court decision is going to be. The other thing that they have to be able to show is that the plaintiffs are going to suffer an irreparable harm if the law is continued to be enforced while the trial is being litigated. Now, in this particular instance, the judge correctly said, okay, well, this is a constitutional right that is being abrogated by the state. Plaintiffs want to buy firearms. They're not able to buy the firearms they want. This is going to be found to be unconstitutional. And more importantly, since it's unconstitutional and since it is a civil right, then the very abrogation of that civil right is an irreparable harm. Every day that goes on where the plaintiffs are not able to exercise a specifically enumerated right is by definition an irreparable harm. The state's response to this is, you have no right to buy the gun that you want. You only have the right to buy a gun that the state feels comfortable with you having. More importantly, the state argues that the plaintiffs already own guns. In statements that had been made at the lower court level, the plaintiffs acknowledged that collectively among all of them, and there's about 7 different plaintiffs in this one, that between all of them, they have about 100 firearms. And the state says, you've already got your guns. You don't need a new one. And as a result, you are not suffering irreparable harms. This is utter arrogance for the state to be making a determination as to, number one, how many firearms you should have, and number two, the types of firearms that you should have. It is effectively the state saying, we simply know better than you do. I will be honest with you, it's consistent with a lot of other regulations that the state of California and other states have tried to promulgate across a broad spectrum of things. In any event, we should be getting a decision on this hopefully by the end of August, beginning of September. Like I said, my suspicion is that the Ninth Circuit is not going to insert themselves in the lower court proceedings, but we shall see. As always, if you would like to email me, you can certainly do so at steven@artemishq.com. And as always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.
Before you go, you just missed one of our best videos that got over 500,000 views. Click right here to watch it now.